Good afternoon, everyone, and welcome to Schmoyer Reinhardt's webinar on tactical employer decisions post-pandemic. My name is Michael Ritter, and I'm Senior Counsel here at Schmoyer Reinhardt. And today I have the pleasure and honor to be co-presenting with Lenita Morgan, who is counsel at Schmoyer Reinhardt based out of Dallas. Before we jump into the exciting topic today, just a few housekeeping matters we wanted to mention. If you are a Texas licensed attorney, we will report your CLE attendance for this webinar online, so we'll take care of that so you don't have to. If you are not licensed in Texas, or if you are not an attorney, we will follow up with an email with a certificate of completion and a copy of the presentation so that you can forward to the appropriate organization for credit. The third issue is that if you have any questions during the webinar about any of the topics that we're discussing, please feel free to use the chat function to type in your question. And at the end of the webinar, we have a Q&A portion where we will be addressing your questions and answers to the best of our abilities. So with that, we'll jump right into our topic of tactical employer decisions post-pandemic. During this webinar, we'll be discussing recent workplace trends, the use and value of documentation from HR professionals and from the employer in adversarial proceedings involving disputes with employees, issues involving virtual discipline and discharge meetings with employees, virtual misconduct and mishaps by employees, managers, and supervisors. And once we cover these topics, we'll also address how to protect the documentation that you work so hard to create and maintain through good cybersecurity measures. After discussing cybersecurity, we'll address the recent shift to remote work and remote work policies and things to consider for such policies. Another underlying factor throughout this entire discussion will be sort of the elephant in the room, which is employee morale and mental health after the pandemic, and stemming from working for potentially 2 years in isolation without a lot of interaction with other employees. And to finish up the webinar, we'll discuss best practices for making strategic decisions and ensuring proper record keeping in an increasingly virtual work environment. So to start with our workplace trends after the pandemic and what we've been seeing is, first, there's been a cool down in regulatory updates. A lot of us really remember those first couple of months of the pandemic because we were shifting something totally new with remote work. And after that, government started enacting laws at the federal, state, and local level about what employers could do in terms of requiring masks, working from home, other issues involving EEO matters such as religious accommodations, other accommodations, disability accommodations. And about a year into the pandemic, there started to be an uptick in intra-government disputes about whether the standards should be set on a federal level, state level, or local level. And we got into a situation where pretty much every single day there was an update with mask regulations or vaccine regulations and guidance from the EEOC and the Biden administration and challenges in the Supreme Court. And fortunately, we've seen a slowdown in that for now, fingers crossed. In addition to that cool down in regulatory activity, we're continuing to see economic uncertainty from the results of the pandemic, the economic changes that have occurred on a national level, and uncertainty moving forward about how issues of supply chain shortages and other regulations that continue to come out throughout the rest of the pandemic, how that might affect the workspace and economic situations for companies and employers. One of the big issues we are seeing that we'll discuss today is returning your workforce to a physical space that you provide as an employer, or having a remote work policy or some hybrid combination of those two, and the issues that can arise with that and how to craft a policy with various challenges in mind. With the transition to remote work during the pandemic and continuing now, there's an increased risk cybersecurity threats such as ransomware, malware, and other bad actors who are trying to obtain information that can end up shutting down and keeping you out of your own files, such as a ransomware attack. It's a situation where a hacker will encrypt all of your files. So all the documentation that you've been keeping, not only for employee matters, but for all business matters, can be kept held ransom by a certain ransomware software. And we'll talk a little bit about the best practices for cybersecurity measures a little bit later. And another trend that we're seeing is what has been referred to as the Great Resignation. And this goes back to a psychologically impacted workforce with employee morale and mental health coming out of the pandemic and coming back to work, and employees realizing that there's a lot more opportunities in the labor market now, and employers with the prospect of employees not showing up for work, having to terminate employees, discipline employees for dependence issues, and then after termination, trying to find somebody to fill those positions. So a lot of issues can come up, and employment disputes can come up through each of those states, the discipline, termination, and hiring. When employment disputes come up, for a lot of those issues, they must be administratively exhausted, which means that the employee will file a charge or complaint with the Equal Employment Opportunity Commission, the Texas Workforce Commission, or an analogous state agency that is charged with enforcing EEO laws and other wage and hour and labor issues. So once an employee files one of those types of complaints, or we call them charges of discrimination in the EEO context, the employer is often asked to provide a response called a position statement. We handle a lot of those position statements here at Schmoyer Reinhardt, and in addition to writing up a written response to those charges, a very important aspect of the response is the documentation that we can actually attach to the position statement to show the EEOC, or Workforce Commission investigator, that it's not just what the lawyers are saying at this point after the fact, but can show the work and the documentation that you've done in the process, ensuring that all your I's are dotted and your T's are crossed. Generally, with that type of good documentation, we have a lot of those charges don't get adopted by the EEOC Workforce Commission for litigation, and the employees issued a right to sue notice. And at that point, the employee has the option of filing a lawsuit against the employer, and that involves another stage of employment disputes where record keeping is so important.
So to underscore what Michael just shared as far as litigation and what happens if a lawsuit gets filed, we're noticing a trend more where to juries and to judges, documents often matter more than a person's sworn testimony. We're also noticing much in legal filings that attorneys and judges are starting to incorporate more pictures and screenshots, text messages, in motions, briefs, orders, and opinions. So it's just becoming that much more significant. And then, of course, during trials themselves, the use of audiovisual equipment and PowerPoints has increased because of the virtual impact that it's had on juries. Next slide. So we wanted to switch gears and talk a little bit more about what is taking place virtually as it relates to discipline and discharges. I wanted to start off with the Worker Adjustment and Retraining Notification Act. This is an act that was enacted on August 4th, 1988, and it became effective on February 4th, 1989. The WARN Act offers protection to workers and their families and communities by requiring employers to provide notice 60 days in advance of either a covered plant closing or covered mass layoff. Next slide. Employers are covered by WARN if they have 100 or more employees. However, this does not include employees who have worked less than 6 months in the last 12 months. This also does not count employees who work an average of less than 20 hours a week. As it relates to employees, though, employees are entitled to notice under WARN. That includes hourly and salaried workers, as well as managerial and supervisory employees. However, notably, business partners are not entitled to notice. Next slide, please. So what typically triggers notice under the WARN Act? It's usually either plant closings, again, mass layoffs, the sale of a business, employment loss, and employment loss, of course, meaning an employment termination, other than a discharge for cause, of course, voluntary departure or retirement. It could also mean a layoff exceeding 6 months or a reduction in an employee's hours of work of more than 50% in each month of any 6-month period. There are also exemptions that trigger notice, and the exemptions, employer does not need to give notice if a plant closing is the closing of a temporary facility, for example, or if the closing or mass layoff is the result of the completion of a particular project or undertaking. This exemption applies only if the workers were hired with the understanding that their employment was limited to the duration of the facility, project, or undertaking. An employer cannot label an ongoing project temporary in order to evade its obligations under WARN. In addition, an employer does not need to provide notice to strikers or to workers who are part of the bargaining unit, which are involved in the labor negotiations that led to a lockout, when the strike or the lockout is equivalent to a plant closing or a mass layoff. So non-striking employees who experience an employment loss as a direct or indirect result of a strike and workers who are not part of the bargaining units, which are involved in the labor negotiations that led to a lockout, are still entitled to notice. And lastly, an employer does not need to give notice when permanently replacing a person who is an economic striker as defined under the National Labor Relations Act. Next slide. So under the notification period, there are certain exceptions which are notable that I wanted to highlight. The 3 exceptions that you see here, the first one is faltering company. So faltering company, this is an exception to be narrowly construed. It covers situations where a company has sought new capital or business in order to stay open, and where giving notice would ruin the opportunity to get the new capital or business, and applies only to plant closings. Unforeseeable business circumstances is another exception regarding the notification period. This exception applies only to closings and layoffs that are caused by business circumstances that were not reasonably foreseeable at the time notice would otherwise have been required. And of course, the last notification period exception is a natural disaster. So this, of course, applies to where a closing or layoff is the direct result of a natural disaster, be it a flood, earthquake, drought, or storm. And if an employer does in fact provide less than 60 days advance notice of a closing or layoff and relies on one of these 3 exceptions, the employer does bear the burden of proof that the conditions for those exceptions have been met. The employer also must give as much notice as practical. When the notices are given, they must include a brief statement of the reason for reducing the notice period, in addition to the items required in notice, in order to give employees the notice that is required under WARN. Next slide, please. I want to talk a little bit about the form and content of these notices. So no particular form of the notice is required. However, what's key here is that all notices must be in writing. And so any reasonable method of delivery designed to ensure receipt 60 days before a closing or layoff is acceptable. The notice also must be specific. So notice may be given conditionally upon the occurrence or non-occurrence of an event, but only when the event is definite and its occurrence or non-occurrence will result in a covered employment action less than 60 days after the event. Next slide, please. So how is the WARN Act enforced? Enforcement of the WARN requirements is through the United States District Courts. The way it works is that workers, representatives, or employees in units of local government may bring individual or class action lawsuits. And in any suit, the court, in its discretion, of course, may allow the prevailing party a reasonable attorney's fee as part of the costs. Next slide. The reason why we wanted to highlight this act is because of a company called better.com. So many of you may have heard of this, but recently better.com, they're an online mortgage lender. Their CEO, Vishal Garg, laid off some 900 employees on a Zoom call after accusing those ex-workers for allegedly stealing from its customers by not being productive. So of course, this was something that was done over Zoom. And so that sparked several class action law firms to investigate the manner and form of the CEO's layoffs and his violations of WARN, given the fact that there was no written notice given to the employees. And the question was whether or not he fell within that 60 days requirement. And so perhaps as a result of the class action law firms beginning to investigate what exactly took place with this mass layoff, better.com later doubled their severance pay for the hundreds of workers who were laid off, offering 60 days of pay, which was up from the 4 weeks, which was initially announced. So initially, they were only given up to 4 weeks of pay, but again, perhaps as a result of the fact that it looked like litigation was starting to arise, better.com changed course. Next slide. And so the effect of what better.com did is that the extended severance pay coincided with the WARN Act framework to give employees 60 days notice, right? So they essentially cured what it is that what he initially did. And so we just bring this up because it's an example of, again, the type of litigation that can arise regarding, the things and misconduct and mishaps, especially regarding discharges or terminations of employees. If that is something that's happening virtually or over Zoom, there are certainly things that companies and employers will want to be cognizant of, even if it's not happening virtually. So next slide.
So aside from claiming that employees have stolen from customers by not being productive, there may be other reasons to consider disciplining or terminating an employee and having to maybe do so virtually. But as many of the headlines from the past couple of years have told us, it's not just employers who maybe don't do things the best way over Zoom and Teams, but there's also a lot of employees who have been engaged in inappropriate conduct on Zoom or otherwise virtually or electronically, and that misconduct being recorded in some way. A couple of the headlines that you might have seen are Jeffrey Toobin, who is an CNN analyst, was caught or was reported engaged in sexually inappropriate conduct with himself. There was a teacher in Alabama in middle class who was recorded engaging in sexually inappropriate conduct with another person. And it's not just limited to video recorded and video software like Teams and Zoom. It is also with regards to emails and employees feeling like they have more security and distance from their employment if they're working remotely, or just the fact that they're behind a keyboard and not actually talking to someone in person, that nobody's ever going to find out about it. We learned recently that that's not the case. Well, I guess we were reminded that that's not the case with John Gruden, who was a football coach for the Raiders and was terminated because during an investigation of an unrelated matter, Gruden's emails came to light in which he was using offensive remarks about other people, and he ended up being terminated, and then he has sued the NFL as a result of that investigation. A lot of these issues arise from the lack of having competence in virtual meeting software. And it's not just limited to CNN analysts, teachers, or football coaches. Lawyers have also demonstrated to some degree a lack of competence in some circumstances. You probably recall the cat lawyer video that went viral, where an attorney appeared at a Zoom hearing and their child had used the computer before them and the cat filter was still on, and the lawyer had to comically explain to the judge that he was not actually a cat. Another instance was there was a worker who was at a meeting, a Zoom meeting, and he decided he wanted to take a quick shower. So he took his computer, or I guess laptop, or whatever device he was using, to the shower, took a quick shower, and left his colleagues perplexed. So what should employees, managers, or supervisors do if they're in a team meeting or Zoom meeting, and somebody is engaging in inappropriate or unprofessional conduct that they're concerned about? One of the methods to report this misconduct is directly to Teams and Zooms. There's in-app procedures for reporting that misconduct, but this could actually be a little bit misleading to other employees who are offended by any sort of conduct from their coworkers or supervisors, because those in-app reporting procedures mean that Microsoft is getting the complaint or Zoom is getting the complaint. It does not mean that human resources is getting the complaint. And so for certain employees, it may be worthwhile to address how to use Teams or Zooms appropriately, and what the reporting and misconduct feature actually entails. In addition to that sort of training and competency levels that are needed for employees who are working remotely or holding meetings virtually through Zoom or Teams, is a policy for what to do if somebody has a recording, if somebody engaging in virtual misconduct. There was a situation that was actually litigated in Minnesota. It's the Miles versus Simmons University case, where a college professor was having class and a student needed to use the restroom, and they were at home virtually attending their class, so they didn't want to miss the lecture, so they took their computer or their device on which they were attending, and thought their video camera was off, but unfortunately that was wrong. The professor then recorded the student using the restroom during class and did not report it to student affairs, did not have a conversation apparently with the student. The professor posted it online. The video went viral, and the student ended up suing the university. And the dispute was whether or not the professor was acting in the course and scope of their employment when the professor posted the video online. The court said no, the professor was not acting in the course and scope of employment, but that did not mean, it meant something for the employer at that point, but that was after a lawsuit, after the media exposure. And, it's one of the considerations that you should account for in if indeed one of these issues comes up. What is an employee supposed to do or not do with any sort of recording of virtual misconduct? And once you have that policy, this becomes a matter of keeping those records in an organized fashion and integrating those records into your existing record keeping system, which is very important to keep safe, as Lenita will explain, and addressing cybersecurity measures.
Thanks, Michael. Yeah, so just to underscore what Michael was referencing regarding cybersecurity issues that naturally do come up, especially that since we are all living in an increasingly virtual world and environment, ransomware, malware, and computer issues have been prevalent for a while, but again, have certainly increased now that everyone most people are working virtually. So a couple of just best practices here that we wanted to discuss is to have a strategy that to include compliant document retention. So as you're going through how to address these issues, a good piece of way to address this is to just show that, or just to make sure that you include a compliant document retention. Employers also want to ensure competency in determining phishing emails. And so that's just a good way to, perhaps offer training to the employees on how to determine which emails are considered phishing emails, Of course, implementing firewalls, antivirus software, and anti-malware is always advisable. Another great reminder is to save all content to the network, not just to a desktop, right? So just ensuring that even if it is more convenient to save to a desktop, that it's always being saved to a network as well. Of course, saving as a backup, right? And we certainly recognize that these things are more than likely happening. We just wanted to underscore this point because of the, like I said, the increasingly virtual environment that we're all working in. In addition to saving a backup, we also want to make sure that we're always using a secure connection rather than a public Wi-Fi, right? So that certainly goes without saying. And the use of privacy screens. So all of these items, as far as implementing certain strategies and things to do, just serves as a good sort of checklist to combat ransomware, malware, and computer issues that certainly do come up. Next slide.
But before moving on, I'd like to emphasize the importance of these cybersecurity measures. Yesterday, I was having a case of the password blues, where it seemed like every account I needed to access, my password timed out, or I needed to update it, and all these emails about antivirus warnings, and it just seemed to be very distracting from the work that I was doing, and I had to put into perspective from an experience I had at I was working for the Texas judiciary just after the pandemic. A couple months into it, the entire Texas appellate court system was attacked by ransomware, and all of our files were corrupted. And there was a note in Russian that was essentially a ransom note that explained that we would need to pay a lot of money in order to get our files back. And the password blues I was feeling from these increased security measures that we have, and that different technology companies have, is paled in comparison to the pain and frustration caused by not having access to any documents. And it's, we talk about virtual misconduct and mishaps. It's not just CNN analysts, teachers, lawyers who aren't always aware of, ransomware attacks and phishing emails by which ransomware attacks occur. It can also be IT individuals. There is a high-level person in the Texas judiciary who put in their email credentials and their password credentials to a phishing email, and as a result, the entire appellate court system in Texas was shut down for a good time. So, just from a personal experience, it doesn't matter how big or small of a company you are, if you're an individual, somebody out there is maybe trying to hack you. So these cybersecurity measures, even though they can be a headache here and there, are definitely worth it. So shifting topics to remote work policies and making the decision strategically about whether to allow employees to work from home anytime they want to, or having some workers work from home, others not. One of the issues that has come up and has been litigated even before the pandemic is liability for at-home injuries, whether that's under the workers' compensation statute in the particular state or under negligence action or lawsuit against the employer. So workers' compensation systems exist in various states, and they vary from state to state, but they generally cover employers can subscribe to those systems and have workers' compensation insurance coverage. A lot of state laws limit employers' liability for separate negligence lawsuits if they provide workers' comp coverage, and a lot of the employers do so. So what happens when an employer who has workers' comp coverage allows workers to work from home and an employee is in fact injured while working from home? What we've seen is that typically these injuries will arise from ergonomic issues. It's an employee complaining about injuries or pain from their way their computer is set up or their chair. But what's been litigated more than ergonomics have been slip and falls in the house, and how does workers' comp come into play with working from home? There have been a couple cases, interestingly, both of them were before the pandemic, which may have been some sort of foreshadowing. But in Martinez versus State Office of Risk Management, which is here in San Antonio, there was an employee who was working from home. She needed a different pen, so she got up to grab a pen, and she slipped and fell, and she injured herself in her kitchen. The workers' comp, she filed for workers' comp. The claim was denied because, according to the court, the employee lacked the authorization to work from home. Interestingly, there's a state law that has a work from home remote work policy in the Texas government code that essentially says all state employees must perform all work at the physical address of the state agency for which they work. And the only way that an employee can work remotely is with the administrative head's written permission. So in Martinez, the court held that the employee's workers' comp claim was not covered because they were a state employee working for the State Office of Risk Management, and the employee did not have express written authority from the administrative head to be working from home, so workers' comp was denied. Coverage may also be determined based on the activity precisely that the employee was engaged in at the time of the injury. The Sedgwick case also concerned an employee who was working in their kitchen, except instead of to get a pen, this employee went to get a cup of coffee and tripped over their dog, and then sustained an injury as a result. This employee also requested workers' comp coverage, and the claim was denied. And instead of looking at the authorization issue, the court said, well, going to grab a cup of coffee and tripping over a dog is not the type of risk that's associated with the particular work that that employee was hired to do. So it did not come under workers' compensation coverage. So those are the issues that can arise at home, injuries, slip and falls, and other sorts of random freak accidents that can occur while an employee is working from home. If the employer is a non-subscriber to a workers' comp system, then the employee can sue the employer in state or federal court, depending upon the situation, for negligence, and saying that the employer had a duty to provide a safe space for the employee to work. Typically, issues of duty and the employer's duty to provide a safe working space is recognized under state law because the employer traditionally has the ability to control the office that the employee is working in. They provide the office, they provide the computer, they provide whatever tools are necessary for the job. But if an employer has a remote work policy and allows the employee to work from home, but exercises no control over the employee's workspace, then the non-subscriber may be in a better position legally to avoid liability than a subscriber under a workers' comp statute. One of the other issues it's non-legal, but it can result in legal and employment disputes, is perceived unfairness in hybrid work situations. Certain employees are totally content with their job, but others experience dissatisfaction, and sometimes employees feel like their situation is unfair, and that potential for perceived unfairness can arise in a lot of different ways under remote work policies. Your at-work employees may feel like they're treated unfairly because they don't have the flexibility to work from home like other employees do. Your at-home employees may feel like they're unfairly treated because they're overlooked, because they're not in the office, they're not allowed to be, so they're overlooked for advancement opportunities. There's a perceived unfairness and particularly negative impact on employee morale if the supervisors and managers, the higher ups, are allowed to work from home, but the other employees are not. And there can also be an option for splitting up remote work to have your FLSA exempts, your salaried employees. FLA is the Fair Labor Standards Act that sets the minimum wage, provides for exempt employees and non-exempt employees. So if you have your salaried employees who are exempt work from home because it doesn't really matter where or when they do their work as long as they get it done, whereas your non-exempt, your hourly employees, there are more issues with maintaining oversight and compliance with overtime laws that can factor into decision about who gets to work remotely and who doesn't. Those can all create a risk of perceived unfairness, which I would identify as one of the main reasons why employment disputes arise. It's not always because the employee feels like something illegal has happened, but it's because they perceive something at the workplace to be unfair that causes them to seek legal advice from a lawyer, who then identifies a bunch of things potentially to sue the employer for. And that's really, for a lot of people, the origin of litigation and employment disputes is the perception of unfairness, regardless of how fair you try to be. It's the perception that they're being treated differently than their employees. So along those lines with perceived unfairness, I think those perceptions are heightened when an employee is, not in good mental health. They've experienced depression, anxiety, and other adverse effects from being in isolation and not being around coworkers, or considering the pros and cons of it all. And so employee morale and mental health is one of the underlying causes for perceived unfairness and employment disputes. And there are resources available for employees that we're seeing, in more of a need for, including employee assistance programs where employers can connect their employees who are struggling with mental health issues or addiction to be connected with a counselor. On top of that, just to maintain the same level of morale with a hybrid workforce, with some employees working remotely or all of them working remotely, is that just more efforts kind of required on behalf of supervisors and management to engage in team building activities and to boost and maintain morale. One of the things that has been done over the pandemic, especially when during the shutdowns where people weren't allowed to, for a lot of places weren't allowed to go out, and where people continued to stay in and isolate, was this concept of Zoom social hours. With anything in a workplace, there's risks everywhere, and you never know how one incident's gonna play out over the years. But there is Lenita and I have both seen in our practices a lot of employment issues arise because of employees at some sort of happy hour or social hour where employees are intoxicated, perhaps acting inappropriately. And Zoom social hours are no exception to that. And so so for a lot of places of employment, you can't control what your employees are going to do after hours, and that's really their business. But if your supervisors or managers are looking to boost morale for something like Zoom social hours, just consider keeping a bird's eye view on that, because they can have legal significance. Zoom social hour was actually litigated recently in Willis v. Harriet case. Harriet was a reinsurance broker at a firm with a non-compete and non-solicitation agreement, and Harriet wanted to have a cocktail hour with other agents and just friends that worked in different places. One of those other places was a potential client of the employer. So there was a purely social Zoom cocktail hour between the agent and the employee as the prospective client. The Harriet, the employee, eventually went to work for another firm, and that firm solicited the company in which that agent's friend worked, who was also attending the purely social Zoom cocktail hour. The court affirmed the non-compete agreement and enforced it against the agent who switched firms, because they said that purely social Zoom cocktail hour created a prospective client relationship with the prior firm. So this just goes to show how even your Zoom social hours can end up having legal significance that end up getting litigated.
Yes, exactly. And to underscore what Michael said just about the legal significance of like your Zoom virtual meetings or Zoom happy hours, We also know that when it comes to documentation for discipline and discharges, it's important that in those actual written communications with employees, that you summarize the actions and accommodations you took to assist the employee before disciplinary action. So it's always a good way to just start the conversation by reminding the employee of the ways in which you, as the employer, bent over backwards to assist them, be it a grace period for some form of leave that was offered, be an accommodation that was not technically legally required, an EAP referral. So it's important to remind them of it. But if in fact these actions were taken for a particular employee, we just wanted to note that it's important to also just ensure that there's consistency across the board. So, if a particular employee is offered a grace period or an accommodation that was not legally required, ensure, of course, that is happening with, employees as it comes up, but also setting a specific cutoff date or time frame in which each specific accommodation was made. Also, for all writings regarding employee separation, also just want to remember to use extraordinary caution in wording. It's helpful to avoid using the passive voice, such as employment was terminated. Rather, we recommend using active voice, such as the employee resigned or the employee quit, right? And in termination letters, also consider the pros and cons of specificity and the reasons for the termination. Next slide.
So in addition to being extraordinarily cautious in termination letters and disciplinary letters and correspondence regarding that, in the process of documentation and investigations and writing up reports, there's a few best practices that we would recommend when doing so. The first is to write the facts as you perceive them, and to avoid, opinions about who is to blame, who is at fault, any sort of speculation. The John Gruden situation, even if you're not using offensive slurs, it just reveals that, it highlights the fact that those emails can always come back years and years and years and years later, and anything unnecessary or excessive or inappropriate can come back. And so it's important to just write down the facts as you perceive them. The second thing kind of dovetails off the notion of as you perceive them. Don't write down what other people say as your own statement or present it as facts. We call that in law a hearsay, which is you're taking somebody said as true because they said it was true. If you're basing your written report or statement based on what somebody else says, make sure to state the report. So employee A said X. Don't say X happened. Say employee A reported that X happened. If you can, the better practice is number 3, to get the employees or the witnesses to write up their own statement. And the fourth recommendation goes along with that, which is to have them sign and date it as well, so that you have a record of what was reported to human resources, to the employer in during any investigation. Additionally, in communicating regarding investigations, it's important to keep the recipients of any communications on a need-to-know basis. And one of the recommendations there is to always review your emails very carefully, going with line by line, starting at the very top of the email, such as the 2-line. These days where you have shortened email addresses where you type in somebody's letter, the first letter of the first name, and it auto-populates hopefully with their email address. Sometimes you get the wrong employee on there. And so it's important to start at the very top and go line by line and just review the 2 fields. If you have multiple email accounts that you send from, that's you can adjust that under Microsoft Outlook. You adjust the from field to make sure it's sent from the right email address, especially if you're using an iPhone or other device where you have multiple email accounts. Check the subject to make sure that that's also appropriate. And in the body of the email, just avoid undefined acronyms and slang, just general advice for emails. Another thing to keep in mind is that unless an email or text message is sent to your attorney, it is not, and it concerns a legal matter, it is not confidential. It is discoverable, and that includes the emails from your private from your private email accounts, and your text messages on your personal phone devices. Those can be discoverable, and a lot of the time the documentation will be helpful to the extent that policies are being followed. But it just emphasizes the point that it's very important to be as careful as possible in documentation of investigations and writing at works. So another area of record keeping and strategic decisions and how to keep that in mind for virtual misconduct is how to best document the misconduct. If you're in human resources and you have a supervisor or manager that comes to you and tells you something inappropriate happened, they may not have any documentation of it. But it's also worthwhile to ensure competency in applications and programs like Zoom, Teams, or Skype to determine so that employees, supervisors, and managers know how to record properly. So some of those software like Zoom and Teams, you can't use the record function on the program unless you're the host or if you have certain privileges established. So employees trying to follow around, trying to record using the program might not be able to figure that out. As an alternative that requires more technological training is how to take a screenshot using the operating system tools. Windows has a snipping tool. You go down to the magnifying glass search function and type in snipping tool. You have the option of being able to take a screenshot on Macs and the OS X. It's Control-Shift-3 to take a screenshot of the entire screen. There's also a QuickTime that can be used on Macs to video record what's on your screen. But that takes a lot of know-how. And so the thing that we see the most is videos and audio recordings on smartphones. A lot of people, they're so ubiquitous that people just have them usually right by their computer so they can just pull it up and start recording something if they need to. Some challenges can arise from that because the recording will be on a personal device and rather than stored on the network or with the employer's documents. And so it's important, as we discussed before, to have a policy that ensures that those records are sent to the right person and not sent to the news media, not posted on TikTok, not posted online, that they're sent to the right person. Another issue that comes up is whether or not you should record one-on-one meetings with employees during termination meetings or disciplinary meetings. And so it really depends on a judgment call made by the employer about what the policy should be. A lot of the times that recording, if you have a termination meeting or disciplinary meeting and an employee perceives it as unfair, their perception of that meeting may be very different than yours. And if there's not a recording, or whether it's audio or a recorded Zoom session, or even notes that you take afterwards, what you say happened at that meeting versus what the employee said at that meeting can result in what we call a litigation of fact issue that requires you to go through the EEOC, all through the trial proceedings, and then in front of a jury, which is very time-consuming, energy-consuming, and just expensive. And so that's a judgment call. But there are laws depending upon what state you're in, what state your employee is in determining whether or not it's a one-party reporting state or a two-party reporting state. So going back to the mile case, just make sure that you have make strategic decisions for yourself about who do you want to train on these functions, if so, and how employees and supervisors and managers can coordinate with human resources to make sure the proper records get to the proper places.
Just along those lines that Michael just mentioned regarding just ensuring that everything is correctly documented. A couple of best practices, of course, is don't delete anything, right? So we know that bad documents are certainly bad, but destroyed documents are worse. So that's, we just want to ensure that everyone's remembering not to do that. Again, these are just reminders. Also screenshots on a PowerPoint versus a jury instruction on spoliation. So it would definitely be better at the end of the day to, have a screenshot on a PowerPoint versus, a spoliation jury instruction, which of course typically informs the jury that it may consider, right, that any missing evidence was unfavorable to the spoliating party, which would of course be the employer in this case. And that's an act that can tilt the case, right, in a trial. So if not harm the spoliating party. So if it turns on that and you're leaning toward, it's going to lean towards favoring the opposing party, that can typically happen regardless of whether or not there was any intent to destroy evidence. And so again, even if it's something as simple as a screenshot on a PowerPoint, it's highly recommended to keep something like that versus risking a jury instruction on spoliation in the event that you are in trial in front of a jury. And also just, it's important to remember to regularly delete documents. Ensure that you have and follow a document retention policy. So this is essential, of course, for any company, but again, it's just a good reminder of making sure that a document retention policy is in place. Next slide.
So far we've covered keeping documents, record keeping, not destroying them, and shifting back to the topic of best practices for remote work policies. Something to consider for such policies and decisions that you make are limiting the times that employees can work and to avoid any sort of wage issues. You just allow employees to work from home, but you don't limit when they can work and when they're expected to work. It can result in some overtime issues and liability for overtime compensation. The next recommendation is very important because we've seen it through the cases that we've already discussed, that your remote work policy should actually limit the place where the employee can do the work. So for example, both of the workers' comp cases we discussed before, apparently the riskiest place for an employee to work from home is in a kitchen. So perhaps a work from home policy, remote work policy could limit the employee to just performing their work, authorizing them to work in an office space that's not the kitchen. Thinking more broadly, during the pandemic, people have had the mindset of, well, if I'm not going into work, it doesn't really matter where I do my work. And some people have even moved states, and this has resulted in a lot of unintended exposure of employers to the laws of other states, such as tax laws, and having to withhold income for some other states, state income tax, or maybe minimum wage implications. And if your employee decides that they want to work remotely from Hawaii, but you're based out of Texas, that potentially means that if they sue you, they could sue you in Hawaii, and that you'll be under the laws of the Ninth Circuit as opposed to the Fifth Circuit. And the procedures and the venues that you find yourself in can be more complex. So limiting the places in the remote work policy can help make things more predictable for you. Another important aspect of remote work policies is to limit the apps and programs that employees can use. You should already maybe be having one of these for at work as well, especially if it's a work-related computer and having the right administrative privileges and authorities to permit employees to download certain programs. But this can be particularly important when you're making decisions about how to train employees to use the features of Zoom or Teams, whatever it is that you decide you want to use for virtual meeting software. Another important aspect of remote work policies is to remind the employees that, to the extent that it makes sense, which maybe in all circumstances that their obligations at home or working remotely are going to be the same as when they're working in the office. And then lastly is just to put the policy in writing. We call it best practices. Practices generally mean something that you do. Policy usually means something that you write down. Your remote work policy should be a policy in writing rather than a practice, to ensure that everybody understands what it is, and to help ensure that it is enforced consistently and to avoid perceptions of unfairness that can cause employees to pursue employment disputes. Which brings us to the conclusion of our presentation today. We've talked about a lot of topics. These are constantly changing and evolving, and the considerations are very complex. So if you're ever in doubt, feel free to contact us or an attorney to review employee handbooks, policies, advise on disciplinary action termination, handle charges of discriminations or even lawsuits and litigation. We've included our email addresses here. There's Anita's and mine. And that brings us to the end, where I guess we have a Q&A session. Juanita, I've been talking for a while. Have you been, have you seen any questions in the chat to address?
Sure, let's take a look.
The question about, are there times when emails to attorneys are discoverable? If so, when and how does that happen? So, Lenita, do you want to take a stab at this, or I can go for it?
Go for it. You can go for it.
Sure. So it really is a case-by-case basis. And generally, if you're contacting an attorney with the intent or with the expectation that they could be providing you legal advice in response to your communication, that generally establishes confidentiality even before you hire that attorney as your attorney for representation. But it's important to note that just because somebody is an attorney does not mean that you have an attorney-client relationship with them, or that your communications with them are privileged, your communications are privileged. Where attorney-client communications can be discoverable are going to be if the client waives the privilege. And that can happen if you're, fortunately suing your attorney for malpractice or anything like that, any dispute between the client and the attorney where that confidentiality and privilege can be waived. There are certain circumstances where if it involves crime or fraud or an imminent threat to somebody, where the attorney might have the obligation to disclose that confidential information to prevent, and in a reasonably limited way, to prevent the injury. But generally, they're not discoverable, and we'll redact and use a privileged log to identify anything that we're not turning over in discovery, so that we can keep all of that confidential. One about recommendations regarding how to organize and store records electronically. Nearly all employers have HRIS payroll systems. You can provide systems for organizing. And this is an issue where it's really whatever works best for you. It's everybody has their own, like, the way that their mind thinks in terms of organizing files that's easily accessible to them. Some people don't have an organization system at all, so even for them it's hard to find things. And so I think as long as you're intentional about how you keep those documents and that you're able to find them easily, it's really about being able to access those documents with ease for you to be able to get to an attorney in the event that those documents are needed for an EEOC position statement or in litigation, because sometimes we're on very short deadlines for that, and the less organized those documents and files are, the more pressure and time that it takes to get those in Another question, since disputes often involve allegations that someone was treated adversely in comparison to others, would we be well advised to have a master system capable of generating reports on all disciplinary actions? For example, categorized by reason, protected class, membership criteria. That's a difficult question. The question is right that in a lot of employment litigation, especially EEO, part of the case that the employee has to prove against their employer is that they were treated unfairly as compared to somebody outside of their protected class. So if it's whether it's outside their sex or race, etc. And so the idea that there would be a neat organizing system for keeping all of that together could be super helpful in the event of litigation. But depending upon the size of the employer, it could make sense if, to some degree. But if you're a smaller employer, then the odds of things getting litigation aren't as high as they are if you have to deploy more people, because sometimes it comes down to numbers. And so if you have more employees, the harder that system comes. But that would be a good software program for somebody to engineer to keep all that data, because that would be super helpful in litigation.
With that, Michael, I think we can conclude. Thank you all for attending this afternoon. We certainly appreciate it. Michael, I don't know if you have any closing remarks.
You nailed it. So that's all. Thank you so much for your time today. If you have any questions, feel free to reach out.